The Constitutional Court has delivered judgment on whether Section 26 of the Births and Deaths Registration Act is unconstitutional, and this is insofar as it unfairly discriminates on the basis of gender by failing to afford men the right to assume the surname of women after marriage. Here's SABC News reporter Canny Maphanga, who joins us from the Constitutional Court. So Canny, parts of the Births and Deaths Registration Act have been declared unconstitutional. Tell us more on the rationale Justice Theron used around this.
Indeed. Good morning to you, Mxolisi, and to the viewers at home. We have yet another progressive judgment coming out of the Constitutional Court. This time it is in reference to the position women carry in their marriages. We've seen that the Court has confirmed that declaration of invalidity, by the Free State High Court against Section 26, subsection 1A to C of the Births and Deaths Registration Act. What that means, Mxolisi, is that men can now assume the surnames of their wives. There is no rational, justifiable reason why a woman has to assume the surname of her spouse, her male spouse, but he too cannot assume that spouse's or the female spouse's surname in the alternative. So essentially that declaration of invalidity has been suspended for 24 months. That gives Parliament at least 2 years to remedy that defect, but the couples concerned, that is Jana Joran, Henry van der Merwe and Jess Donnelly Bornman and Mr. Bornman, have successfully vindicated their constitutional rights to equality and dignity by ensuring that they have the choice, and now many others, to take on their wife's surname should they do so. The analysis that the Constitutional Court employed was the impact that this kind of legislation has on women, and they found that it was an insidious impact because it is rooted in patriarchy and enforcing those colonial gender norms. It has no legitimate government purpose but to place women in an inferior position in marriages once they assume their male spouse's surname. So once again, Polisi, quite a progressive judgment from the Constitutional Court. They found that this legislation has a severe impact on women in marriages and does not serve a legitimate government purpose. So of course, they have successfully confirmed that declaration of invalidity. That means now all in society have a choice, if they choose to do so, to take on the surname of their female spouse. And of course, now women are not placed in a position where they have to lose their identity in marriage. They now can be placed in a position where, should they choose to make their surname the family name, that is now possible because legislation will now support it. Over to you in studio.
And Canny, while still on it, I heard this is a sort of an interim sort of remedy to this matter, which would now mean that, as you mentioned out there, that Parliament has about 24 months to deal with this matter. Am I correct?
Yes, that is correct. Because Parliament, that is where our lawmakers sit. The Constitutional Court has identified the defect, confirmed the defect. It is now up to Parliament to remedy that defect and choose how they do so, whether that is introducing new legislation or affecting the changes. And of course, that is suspended for 24 months. They're given that period to do so. But because the Constitutional Court has confirmed that declaration of invalidity, that now comes into effect, which means that men can now assume their wives' spouses if they choose to do so. And then, of course, with respect to the applicants, the two couples that brought this bid here to the Constitutional Court, the Department of Home Affairs has to remedy the change in surnames that triggered the application to begin with.
And is that couple present in court today? I'm wondering what their reaction would be if you've managed to touch base with them at this moment.
Well, they were present during the main bid, which was heard in March earlier this year. However, during judgment, they did not come to the court this morning. We know that they're all legal practitioners as well. They may have had other engagements, but I'm sure we'll be able to catch up with them at a later stage to see their reaction to this historic judgment that kind of embodies the constitutional democracy that we enjoy today, that ensures that the right of equality and dignity is afforded to all, particularly women once they enter marriage. Over to you in studio.
Right, that's Canny Maphanga working that story. Thanks so much for that update. And at the back of that, we also rehash our question for the day right here on the agenda this morning. At the back of that judgment that was just handed by the Apex Court, we ask you, with the Con Court that has just handed down the ruling on the spouse order today, do you think husbands should be allowed to adopt their wives' surnames? Please do share your thoughts with us on our social media platforms. We are on X as @theagenda_X. You can also call us on 011 714 0661 or 0662. We look forward to hearing from you.